fun. Okay, so the topic for this presentation is wills and pets. We're looking at a case study. We've been given a case study of Emily Nancarrow, and Emily has died with a will. So we don't have to worry about the rules around dying intestate or without a will. This leaves her property, $750,000, to her pet dog and then to the RSPCA. Emily has 4 children who are unhappy about this arrangement. So we've got 2 legal issues that are important here. Is one, do the children have the potential to challenge the will? And we'll look at the legal elements of that. And 2, should the law around pets being beneficiaries of wills be changed? Not just this case, but in a broader sense. So there are some important elements to a will that we should think about. It's a legal document that gives instructions to how a person's assets should be dealt with once they have died. Widely recommended that anyone over the age of 18 should have a will. And according to the Succession Act, the Queensland legislation, there are 4 key elements to a will. It has to be in writing. So we assume in this case that Ms Nancarrow had written a will. It has to be signed. We're assuming that this has happened. It has to be witnessed by 2 people who are not beneficiaries. Well, her beneficiary is a dog, so that's unlikely to be a problem because the dog won't have been a witness. And it has to be made freely and without due influence. And one imagines that it has, although there may be a couple of questions that we could ask around that. And the undue influence, that might be if RSPCA has somehow put some pressure on her to be included in their will. And if we think about it, the dog is not going to consume much of the $750,000 from the will. Even if they have some serious medical issues, it's an old dog. We're talking an amount of tens of thousands of dollars. The vast majority is going to end up with the RSPCA. And so unless they put pressure on her to include them in the will, we can rule out undue influence. But when we think about it, a recent case that has looked at what is undue influence is the Nicholson versus Nags case, 2009. And it was talking about someone being coerced into action. That's what we'll be looking for with the RSPCA. Have they coerced this lady, Ms Nancarrow, to sign their assets this way? One reason we think that they may not is because if they had, they may have immediately given that money over the RSPCA and left just a smaller amount for the dog. Right, the issue of the daughters. This becomes more interesting. Are the daughters have potential to challenge this will? And again, going to the Succession Act 1981, sorry, I've misprinted that as a Success Act, it should be Succession Act 1981. It does provide that if a will doesn't adequately provide for a deceased's children, that there can be an effort to challenge that. So if we think about the facts of the case here, no provision has been made for the Nancarrow children at all, whereas $750,000 was left to an elderly dog. This raises an issue of capacity. One of the key elements in making a will is you have to be able to be making the will, have to understand what you're doing with it. So maybe there is a question, was Ms Nancarrow in a position to be making a will if this was her best judgment, that her dog gets $750,000 and her children get nothing? An interesting side issue here is that Ms Nancarrow was predeceased by her husband. Should the law consider his wishes, assuming that his property was likely part of Ms Nancarrow's estate and now form part of her estate? And would he have wanted the children to have received nothing and the dog to be the richest dog in town? Okay, so what should we do with the daughters? The Succession Act 1981 is clear. The children have a right to be considered when a parent dies. So on this basis, and assuming the daughters had a reasonable relationship with their parents and have a reasonable use for the money, so that is that they don't have huge sums of personal wealth, they haven't married into the Gates family or something like that, and so that they do have a reasonable need for this money, then they should challenge the will. And importantly, you only have 9 months to do that, so they need to do that within a reasonable time frame. So the further legal issue is this: how do you provide for a pet in a will? New South Wales Law Society suggests a number of ways that a person could do this. They could set up a trust with assets specifically for the care of the pet, a program like the RSPCA where bequests, so bequest is like a sum of money is paid from the will in exchange for the promise to care for a pet, or you could just ask a family or friend to care for your pet. So those ways. But are they good enough? A key problem, sorry, I've left out part of a thing there. So a key problem in this case is there isn't a brilliant framework to best care for a pet for someone who wants to. Obviously, Ms. Nancarrow cared a lot about her dog, and that became a really central thing for her in the end of her life, and knowing this dog was cared for. So I propose that there should be a change to the legislative framework to address that. And the key elements of this change would be that a maximum of 10% of the value of the assets of a will, so $75,000 in Ms. Nancarrow's case, can be left to care or left to a pet, effectively to care for a pet. This can be done through establishing a pet care contract from a will. The person nominated by the deceased may accept the sum of money and the responsibility to care for the pet. A number of people can be nominated. So there might be 3 or 4 people. If none of those choose to accept the care of the pet, the RSPCA does this. To enforce the importance of the role of the carer and to give more peace of mind for the deceased person, any cases of pet negligence from a person who accepts a pet through the pet care contract faces a doubling of any penalty. So doubling of a jail time, doubling of a community service order, doubling of a fine. These help the situation in 3 different ways. They provide a simple and easy way for people to care for their pets in a will. They limit the amount that can be given a pet. So we don't have a situation where Ms. Nancarrow's daughters see $750,000 go to an old dog and nothing from them. And the 10% rule diminishes any legal challenges that come around with large bequests to a pet. So in this case, one of the key reasons this is being challenged through the court system is that a really large sum of money, far beyond what a pet will be used, has been left to a pet. And so by limiting it to 10% of an estate, it means that it's a sum of money that isn't hugely important. So with this, I have put together a draft of what a draft might look like for this. A draft of the legislation. And this gives you some idea of what it is. So it's the Proposed Succession Laws Amendment 2015. Clause 1 limits the amount to 10% or $25,000, whichever is the greater. The testator may nominate 3 people who would like to take on the role. The RSCPA steps in if no one else does. The money can only be used to care for the pet until the pet is deceased. And if there is a conflict around treatment for the pet, then it is the vet who makes the decision about what happens there. There's a doubling of animal cruelty fund. If there's unauthorised spending, the money has to be replaced at a factor of 1.5 times. And the person who takes on the pet care contract receives the balance of funds once the pet moves on to another life. So,